Hi everybody, Ray Hayden here, and this video is going to be about the California bar exam and the performance test. Upcoming in a couple of days, July of 2021, the last week of July 2021, we got a bar exam in California. It's a remote exam that we take on a computer, which is because of the pandemic situation. So for my friends and family from the YouTube network and everything else, I greatly appreciate you coming by. But this video is for a specific purpose of the California bar exam. So if you're not interested in the California bar exam or taking a performance test on that exam, this video is not for you. I greatly appreciate everybody stopping by and hanging out and saying, hey, but in all honesty, go check out one of my other videos. This is specifically for people who are really cramming hard for the California bar exam that's coming up at the time of this video in the next couple of days, all right? So thank you very much for coming by. Now, for everybody who's hanging out looking for the performance test information as I put it forward, thanks for hanging out. I appreciate you checking out the video, and I really, really hope that it helps, and I really hope that everybody passes the exam, especially people, the attorney's exam, because it's hard, because people have been away from the exam for a while, so it's more difficult, and also for people who have jobs on the line. I really hope that all of you folks pass. It's pretty vital that you do, and I really want you to be able to have that opportunity. I also want to give you the fact that I'm not a subject matter expert on this, and I've sat for the exam 5 times. This is my 6th attempt, and on the performance test alone, I've hit performance test. I've hit a 55, a 50, I hit a 60, a 50, and then last time in February 2021, when I was doing so great on the essays, I hit a 45. If I had hit a 65 on the February 2021 exam, I would have passed that exam. It's actually a good thing that I failed, and it's a great thing that I got that 45, because that's what really, lit the fire, as they say, to get me to figure out a way to more effectively, efficiently, properly, professionally, and as expertly as I can, get the answer down that the graders want to see to give me all those tasty, juicy points. First thing I want to do here is get rid of my face on the screen, so let's go ahead and do that. And let's jump into the exam. In October 2020, we didn't have this 50-50 screen that you see now. We do have that in the exam that we're about to take. This is roughly what our exam is going to look like. Obviously, I'm using the, what is this, Adobe Acrobat Reader kind of thing, but this is really what it's going to kind of look like. There's some different borders on the actual exam. If you're taking the mock exams, you know what I'm talking about. There's a blank sheet of paper because I'm going to show you what I've done when I get into there. Let's look at the performance test, and this one here is like really, really confusing. It's a mess, and it caught me. I actually fell for the trap, and I got my head handed to me, but I still scored better than that 45, right? So go figure. And my formatting was horrible in this one here because this exam got screwed up, and my files got corrupted, and all the formatting that I put into the exam got wiped out. So when I open up the performance test, the very first thing I do is I go to the task memo. Now this says instructions and file. So here's the instructions up here. They're the same for all the exams. And then here's the file. In this particular one, it's got 3 documents in there. The first one's the memorandum to applicant. That's the task memo. And it should be the same all over, and no matter which one you take. The very first thing should be memorandum to applicant. That is our task memo. That's the thing that everybody's been beating into their heads day in and day out to know what you're doing with your task memo. Now I want to do a little side thing here and talk about the PT book by Basic and Schindler. It's an excellent book. I did not read the entire thing. Actually, a lot of it is the actual working on the performance test. I think it's an excellent book, but I got to a point early on in the book, in the first chapter, I read, we have to have an introduction paragraph. And I realized I've never done that. So because I've never had a introduction paragraph, and I have been able to hit a 60 on the performance test, I believe that I should be able to hit at least a 65. So a minimum of a 65 is what I should have in me just by having the introduction paragraph and then making the rest of my performance test look presentable like a passing essay, all right? Or a passing performance test. So this is from Marjorie Turner. She's our boss. The next 2 documents here are the fact file. That's the rest of the fact file. That is the fact file. The first thing is just a memorandum to us, so let's see the instructions. These should always be the same. Feel free to peruse these on your own. Download the October 2020 performance test and everything else. And I think I might upload it to the Ray Hayden discussion group. I might upload this particular document there too, so you can just grab it right there without having to go search for it on the California Bar site. All right. So These instructions should be the same everywhere. Read them as you will for what you need. But the first thing is a performance test task memo. That's a mouthful. So this is a task memo. This is to us from our boss or supervisor or boss, Marjorie Turner. Now, I don't think we're, all good to call her Marge or Marjorie, so I'm going to call her Ms. Turner. So Ms. Turner here is writing to us, telling us about our client, and she's a longtime client and retained us on credit cards run up by her son for online purchases. All right. I'm just going to read this to you right here. I'm going to read this first paragraph. Janice Wright, a longtime client, has retained us on a matter concerning unauthorized credit card charges run up by her son, Ryan, for online purchases connected to an online video gaming website called GamerTracks. At Ryan's request, Janice gave him permission to open an account using her credit card. She told him he could charge no more than $20. He ended up charging $9,000. After receiving her credit card bill, she sent a letter to GamerTracks asking for a reversal of the $8,980 charge, but GamerTracks declined. She would like our help in determining whether she can avoid paying some or all of these charges. All right, so that's that paragraph up there. Let's read this part here. This is the actual task memo. This is what we're being asked to do. Our boss, Marjorie Turner, has determined, and I'll just get rid of the highlighting. I have already determined that Ryan was able to and did in fact enter into a contract with GamerTracks. So that I may discuss this matter with Janice, please prepare a memorandum that answers the following questions. Number 1, is Ryan able to disaffirm the contract? Number 2, if so, did Janice's letter disaffirm the contract for Ryan? And number 3, is Janice liable for the $8,980 charge? So what we're learning out here, the first thing we get in this instruction to us is that there is a contract. Ryan was and did form a valid contract. We don't have to go through formation. But Ryan is a minor, so there's a special thing that we may recall from school and studying for the bar, that it's a minor entering a contract, and they got special rules. Lo and behold, the performance test is indeed a closed universe, and everything we need is enclosed in this document. The problem is, unlike an in-person exam, we can't flip through pages back and forth willy-nilly and very rapidly. We have to scroll through the exam, and it's a pain in the neck. In all honesty, I don't expect for it to be that bad, but for October, for me, it was a nightmare and a half. But this one here will be 50-50, and if you did if you looked at the materials, which had this one on there, I believe in the mock exams, I think this is the one that they gave us maybe, but if you look at it, you would be able to tell if you can read the stuff that's on the right. If it's large enough for you to read, you're doing good. Up here, kind of in the same area in the actual Exemplify software, you can see the visible. Now I want to say something about this. If you look at the bottom of my screen here, hopefully it shows up, there's a scrolling thing and some of the letters go off the screen. So that's 107% up here. You can also highlight that and type in, I want to look at it at 100%, and there it is. The scroll bar is still there on the bottom, but there's space, the margins are there so that none of the text goes off the screen. So if you want to maybe go, they say what, fit to visible, but maybe that's just, it's going to mess things up. Say, 105% maybe. And what you want to do is you want to make sure that none of the letters go off the side, but fit to width, hopefully fit to width will be the thing that gets the job done for you. I just really wanted to mention that because when I was helping out a cohort of mine in going through the mock exams, we had that issue where on her computer, she was having a hard time reading the computer. So, hopefully you'll be able to read it and not have a problem. So let's get into what I do when I first open up the exam, right? When I open up the performance test, I jump right to the task memo, and I'm telling you, in this particular instance, this is the task memo to me. My opinion, my personal opinion, you can agree or not, but to me and what I'm going to write, this is it. This is what I want to know. So I'm going to write this, and I'm going to reword it in such a way over here in my answer window, and let's go ahead and look at what I wrote. Bingo. So I wrote this. This is my answer to what I see here. If you look at it, it says Ms. Turner. Let me get rid of the highlighting here. Ms. Turner, please find my reply to your request to provide specific answers to the following questions. Can you disaffirm the contract? Did she disaffirm the contract? And is she liable for the $9,000? Please find the answers below, and if you have any further assistance, please. If you need any further assistance, please contact me at your convenience. It's a funny sentence to say. And I signed it off, applicant. All right. Now this is from what I know so far, which is nothing. All right. I don't know anything yet. This is what I know, and from that, I'm going to basically write a template, an outline in my answer for how I'm going to answer the question. This is my introduction paragraph, right? Kind of. So this right here is what? It's all bold. It's, standing out by itself and everything. And we look and we say, well, they're the same answers that are up above. Yeah, they are. But here's the thing. When we do a performance test, the thing that they're going to be looking for most of all is, did we answer the question? If I go in here and I treat this first question as an issue, right? Yeah, your issue, your rule, your analysis, maybe some court discussion or whatever, and then a conclusion, all right, you've answered the question. So if I did that for all three of these, then yeah, I've answered the question. How well I did that, that's another story, but at least I answered all the questions. I should get a 50 or 55 on that. Yeah, I did it. I got the thing down and I did it. Now, did I make it as a memo? I don't know if they really care about that, in all honesty, but let's go ahead and see what the next thing is that I go and look at. Here we got a fact file thing, got a couple of pages, just 3 pages of fact file, and then we get into the library. I always think law library because that's where the law is. It's in the library. So we go in here and the next page we see is the table of contents for the law library. And it's like, okay, well, we got our cases here. We got Miller versus Miller, Brady versus Thomas, and Laredo versus Purcell Fruit. And I got to make a little side note here as you look at the dates. These are the years in which these cases were decided. It also says where they were decided. This is the Columbia Court of Appeals, and this one went all the way up to the Columbia Supreme Court, all right? This one here is in 2004. So this is the newest case. The next newest case is back to 1963, and then the other one goes way back to 1950, right? So we're going to be talking about 100-year-old cases soon enough, right? So there you have it. So I've heard in some of my preparation documents or preparation program materials or whatever, look at the newest case first, okay? And that might be something to do. And then look at them in order, newest to oldest. And also, this is a Supreme Court case. If there's anything from a lower court, which this court is, the Columbia Court of Appeal is the lower court to the Columbia Supreme Court. If there's something from the Columbia Supreme Court that they outrank the other court. So if there's something here that conflicts with these other two court cases in any performance test, it's something just to know, the Supreme Court case wins. Unless it gets back up to the Supreme Court and they make a different decision and gives a rationale why. But other than that, the first thing I'm going to do in all of my, no matter what, the next thing I'm going to do is I'm going to grab the cases. And I did. Now, I want to make a note here for anybody who's I've been working with or whatever, or talking to and everything, when I share my information. Basically, what I had done on previously on my initial experimentation and stuff is I would grab the cases like that, and I wouldn't have the Miller thing and the Brady and Laredo. But in talking back and forth with people, they were like saying, well, you only have to refer to the Miller versus Miller as the Miller case, and Brady versus Thomas as the Brady case. Yes, that's true, okay? But by having all this information into the thing, and also like this, number one, it takes up less space, and number two, the way I formatted it here with the italicized in bold, that's the case, that's the court, that's the year, and this is how I'm going to be referring to it in my answer. But this entire thing is going to show up once. Somewhere in my personal answer, Miller versus Miller, Columbia Court of Appeal 1963-Miller, in parentheses like that, that is going to be in my answer. And then anywhere else in my answer, it's just going to be Miller. I'm not going to be duplicating my effort anytime I talk about something from the Miller case, all right? Now, we also have these things up here. What in the world are these? Well, the first thing is they're going to give us some Columbia Civil Code, and then they're going to give us some Columbia Family Code. Until you scroll down there, you're not going to know what's there, what's what, and what's going on and everything. But there, you got two sections. There's going to be a select provisions from the Columbia Civil Code and select provisions from the Columbia Family Code. I didn't put them here. I put the cases here because I know what the cases are. Miller versus Miller. All the information I need is right there. So I put it right there because I see it, I know it. Select provisions, what am I going to write for that? I have no idea. So I'm pretty much not going to write anything, right? Well, here's what they are. And this is what screwed me up on the October exam in person. I see all these things and I see all this writing and I'm like, what the heck are they trying to do to me? What are they telling me about? And then we get to the Miller versus Miller case down here, right? And this is the problem, and this is why I want to clear it up. If you see something goofy like this, if you see something goofy at all, stop, take a couple of breaths, take your time, because you may never be looking at it again in fine detail, but look at it. What this is agency defined. Section 3800 is agency defined. That's all it is. And you look at it. Agency is a fiduciary relationship, and you're already saying to yourself, I know what this is. I already understand that. Yes, you do. Why they're putting it here again, I don't know, but it's not going to be the only time we see it. And then we see Section 3801, actual authority. We know what that is, and we know what a parent authority is. We know how you create an actual authority. Actual authority, a parent authority, and creation of, So they're really giving us everything right there. They're giving us everything we already know. And then you look down here at binding effect. There's 3 stars here. Now, this is kind of a funny thing, but I'll tell you my guess for why I think it's there. If you look at these things, this is 3803, I guess 3801, 3800, 3800, 3801, 3802, 03, 04, and then it skips to 3810. Because you're skipping section numbers, I think they put those 3 stars there. Again, you see something strange, something kind of freaky, goofy, whatever, don't worry about it so much. Just kind of, you get the idea, move on. Now we're going to scroll down to the next section, and they're going to give us 6701, 2, and 3 of the Columbia Family Code, okay? Now, we know already from our questions up here that Ryan's a kid. We already looked it up over there and everything else and read the task memo. We know that Ryan's a child. He's a minor. So what are they giving us this for? Well, that's information to work with. But they're giving it to us up front. Do we deal with it now? How do we deal with this? Where do we put it? If it was like my cases below here, like Miller versus Miller, like on here, okay, if it was like the cases up here, okay, I would just type it into my answer. Because they're giving us so much information up there, I would just type it in my answer. But I don't see that. So in my actual answer that I really did, I started typing all of this stuff into my answer space, right? I figured it's going to come in. I'm going to have to talk about it. But do we really? Okay, so you got to make a judgment call on that. And had I just read everything up front first, I would have saved myself a lot of effort and wasted time. Okay, so let's go into Miller versus Miller and see what I'm talking about here. Okay, what we see up here is this case from 1963. I just want to read a couple of bits of information because I know I've read all this stuff a number of times. I know what it's about. So I'm just going to read this paragraph right here. The first one. By his complaint, Bryce Miller sought judgment against his mother, Josephine Miller, for $26,000. Now, that might not seem like a lot, but back in 1963, that was a chunk of change. All right? $26,000 representing payments issued to him when he was under 18 years of age under a contract of employment as an actor. Contracts, minors, and all that kind of stuff. Bryce now appeals from a judgment in favor of Josephine. So what in the world is this saying? This is the Columbia Court of Appeal. He went to a state court in Columbia, sued his own mother for $26,000. She won the case, so he lost, so the child lost. This next one here gives us more information about that. And the important thing here are if you see dollars and stuff and dates and things like that, I guess this child was paid $1,000 per check because there's 26 checks and it's $26,000. And they went to Josephine and she endorsed Bryce's name and deposited it in her own account. Okay, so here's the important part of this paragraph. She has taken possession of the checks, 26 checks, $26,000. She put them in her own checking account, her own banking account, whether savings or checking or whatever. She took the money, his mother took the money, the $26,000, and put it in her own account, and Bryce authorized Josephine to use the money to take care of both of us, all right? So Bryce is authorizing his mother to hang on to that money in security like a trust like a support trust that he's doing for himself and his mom to take care of both of us, okay? So now, by this action, Bryce seeks to recover the $26,000 received by Josephine. And there's no doubt, okay, and this is the court discussion. This right here, and it doesn't say it, but this is courtroom discussion, judge discussion, and then they're going to come up with analysis and a conclusion. So to me, this is like analysis and conclusion. But the funny thing here is they say the Columbia Family Code 6703. Now, when I was doing this actual exam on exam day in October 2020, I wrote it down. It was in my answer file. So I already had it. It was over here somewhere in my answer file. But here, in this example here, I didn't write that. I didn't put it in there, right? I went down and I wrote the cases, but I didn't write these section numbers. But so now, I might want to make a note in my answer somewhere over here, and I have to go down a couple of spaces. I might write down, and I don't want to write Columbia Family Code every time, so I'll write CFC 6703, right? So it's the Columbia Family Code, section 6703, and I'm just write stood in the way. And as a matter of fact, I'm going to add unless, all right? Unless. And now I also got this in a bad position right here because this is specifically to the Miller case, right? I don't want to copy it. And as a matter of fact, it doesn't need that little space either, all right? So I'm going to X this. I don't do this on the exam. I copy and paste. All right, so Miller v. Miller, I might make I may make a note about each one, right? Okay, so let's say minor. These are my notes just for how I'm going to answer this thing. Minor suing mother appeal. As a matter of fact, it's the appeals courts, right? Appeal case against mother for $26,000, which was what's a judgment. Well, he's appealing that, so we know she won, and he's appealing that. He wants the $26,000. So then in this one here. Bryce entered into a contract with Joseph. Okay, so Bryce was entered a contract with Couch Studios, Inc., all right, to portray a role in a television series. At the time, he entered into a contract with Josephine under which she would relinquish any right to any money paid to him pursuant to the... Okay, this is important. Okay, at the same time, he entered into a contract with his mother under which she relinquished any right to any money paid to him pursuant to his contract. I got to tell you something here that you don't know and they're not going to talk about. Back in the day, your parents could take your money. You're living at home, they're providing for you, they can take your paycheck. I don't know if it was the same everywhere, but I know my parents threatened me with it, and I said, then I'll just quit working and you can support me 100%. And they're like, okay, never mind, keep your paycheck. So there you go. So contract with Josephine. I'll just write her name in here to as a note. Let me see. Where she relinquished. My spell checker might work, but sometimes the one that's built into the software doesn't work so well. Any right to any money paid to him. So guess what's going to happen here, right? Pursuant to his contract with Couch. Now with Couch, I'm going to write in who they are, Couch Studios. Couch Studios. Right? So that's my note. These are all under Miller versus Miller. Now also I'm going to go down here to the bottom and I'm going to put some more space in here. These are my notes for the Miller versus Miller case. All right, minor appeals. Maybe I'll write his name in there too. It doesn't take long to do it, so we'll say Bryce. So Bryce is suing Josephine. Might as well put her name in there too, right? Josephine for $26,000. And the contract with Josephine entered, Bryce entered, right? A contract with Josephine where she relinquished any, don't need the capital there, but Bryce entered into a contract with Josephine where she relinquished any right. By the way, I'm not going to go through all three of these cases like this. I'll just do this one here as an example for what I do. I put the cases up there, and then where I have the information from the case, I put my notes here where I will again, address these, fatten these up, and make them where they need to be. But I'll go in order. This is from the first paragraph. This is from the second paragraph. And it says, now we say, pursuant to the contract, Couch issued to Bryce 30 checks in the aggregate of $35,000. Of these, Bryce endorsed and deposited 4 checks in an aggregate amount $9,000 in his own account. So he's got $35,000 minus 9 is going to be the 26 checks, right? 35, 26, 30, 20, that's only 4 checks. oh yeah, 4 checks, right? So he's got 4 checks for $9,000, and he put that in his own individual account. And then at his direction, Couch delivered the other checks in the aggregate of $26,000 to Josephine. She endorsed the checks and put them in her own account. And now I probably want to make a note of this. Bryce authorized Josephine to deposit. It was the $26,000, right? $26,000. Bryce authorized Josephine to deposit $25,000 in her own account. I'm making up words here. I'm going down to this bottom. I'm pointing at the screen like you can see it. I'm going down to this one here, and I just want to get this information in here, but I'm kind of playing with the wording a little bit. Authorizing her to use the money, right, to take care of both of us. Right? Okay, now, and again, I went to the bottom of the thing and I said, this is important stuff down here and everything else, but I need to pop back up here and see what's going on because I saw the code, right? I'm going to need to know about that. And it says, let's go. By this action, Bryce seeks to recover the $26,000 recovered from received by Josephine. There can be no doubt that Josephine held this money for Bryce. By her contract with him, she had relinquished any right to any of it. Okay, that's from that paragraph above. She, they got a contract with his mom. She relinquished any interest in any right to any of that money, and he's entitled to recover all of it, except for, because he said up here to take care of both of us. Okay, that's important. And that kind of sticks something in my brain a little bit, unless Columbia Family Code Section 6703 stood in the way. Okay, so now I got to make this little note here. Bryce is entitled to recover. Let me see. No doubt. Entitled to recover all of it. Bang. Unless CFC stood in the way. So we're going to need to know a little bit something about that. I'm going to put a comma here because I don't like that little squiggly line. There we go. All right, so I'm grabbing information from that case that's kind of really important, right? Under that provision, and then they're going to tell us. So here it is. So under Columbia Family Code Section 6703, right? Because under that provision, okay, a minor under the care of a parent who is unable to provide for him may contract to pay the reasonable value of things necessary for his support and that of his family and may not disaffirm such a contract. This is the courts doing analysis. Like we got to do analysis. This is the court doing the analysis of this section and whatever else is around it, which happens to be 6702, I would assume, the disaffirmation of a contract. And then this being true, it must follow that the minor can authorize the use of money held for him for those purposes and cannot recover any money thus paid out. In entering a judgment for Josephine, the trial court found that she expended the $26,000 she had received for herself and for Bryce. So she spent the money. If she's spending the money for things of necessity, food, health care, shelter, then he can't get that money back because he put that money to take care of both of us. And if she's using that money for those purposes, then 6703 is saying she can't have the money or he can't have it back. She's supporting you with that money. You put that money in there. She couldn't support you. You could support you and your family. So she would be able to keep all that money. And I'm just assuming that that's what that is, unless it's stood in the way. And we'll have to address that. It says, this being true, it must follow. Okay, I just read that. It says, entering a judgment for Josephine, the trial court found that she expended the money she had received for herself and Bryce. So she did spend the money. The trial court find that. Finding that, however, was insufficient to support the judgment. The court did not find that Josephine expended the money for herself and Bryce for things necessary for their support, which must be right there in 6703, nor could the court have found found. The evidence showed that in all relevant times, Josephine had an independent and substantial source of income. So Josephine's already loaded. She didn't need his $26,000. And it also showed, the evidence from that case, showed that she had expended the $26,000 she had received, as she herself admitted, for the good things of life, not necessities. So she's having a party with his money. So I might make a note here and then come back and review this if I need to, but court finds that Josephine expended, I guess, right? Expended the $26,000, because the first court found that she spent the $26,000, right? So now this court's agreeing with it. Well, yeah, she spent the money. That's gone, right? Not, right? Maybe you want to make that bold too, right? Bold, not, and then put it in italics, for things necessary for their support. And then take it off italics. And then I'm going to space this out again so it's not all bunched up, right? So it's easier to see, right? And then I'm going to skip that, nor could they have found it so. The evidence showed that. This is all coming right out of the thing. This is my own writing. That, at all relevant times, Josephine had an independent and substantial source of income. I'm going to that other page. Income. And then I'm going to make more space here. It also showed that she expended the $26,000 she had received as she herself, that's a funny sentence, right? Admitted for, and this is good, for the, quote, good, things of life, comma, not necessities. All right? Judge, and then judgment is reversed. Make a note of that. Judge meant reversed. Bryce. I don't want to put a dash. Bryce. CE. Again, this is my note. I might change out the wording of this and everything else to the $26,000. All right, so I would do this on each case, right? This thing here mentions code 6703, right? Stood in the way under that provision of minor blah, 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 right? Now, this is where I would put that, right? So CFC 6703 would be something that I need to kind of head note here, right? And I'm using this shortcut, and we'll get back to that in a minute, right? Now, I'll show you down here that I do have that information kind of put in there. So let's get to 6703. Let me see, provide for the minor and his family. So here's actually the whole thing, right? And I'll take this, and this is, now I've already typed it into my answer space here. So I'm going to take this, I'm going to stick it in back up here. And then I'll explain this in a second, right? So let's go here and paste that right there, right? And this doesn't all need to bold. It shouldn't be bold at all. All right? unless CFC 6703 stood in the way. So here it is. So they said it. I'm going to include it here, right? So this is the first time, it's the first case. And it's the first time I'm mentioning this CXC, a minor has the power to contract, right? It's in the thing up here. Let's go back up to that. 6701 is the minor has the power to contract. Like, your kid's got a contract, they don't have, that's not the issue in the case. The 6702, the minor has the power to disaffirm, all right? They can disaffirm it. And this minor is disaffirming his contract. It's not really disaffirming his contract. He's saying that the authority that he gave his mother to put the money in the bank is not her money to put in the bank. And she didn't need that money. She had a substantial income, and she spent that money, the $26,000, she spent it for the good things of life, not necessities, down here in my answer, which I copied out of the performance test over here, right? So she spent his money. He made good money. He put it up in there to, just in case, we got to take care of us and everything. Things go bad with your substantial income, mom. Here's 26 grand back in 1963 that might just help us out, right? So there you have it. But she had enough money and everything else, and she just took his money and pretty much spent it on the good things of life, not necessity. And so these are the notes I'm making underneath that particular case, all right? So what I'm not going to do is I'm not going to go through all of that for these other two cases. We're going to be here forever, right? So, and I'm talking about it, not just simply doing it. So I was like, I'm simply doing the answer, and then you can see what I did is I format this thing into a more pristine work of art, right? So I went to the first case, did that. Now we go to the second case, is Brady versus Thomas, and I do the same thing. Now I'm not going to go through it here, but I look at each paragraph and see if there's anything going on. I'm kind of scanning, and I kind of know what I'm looking for. Guess what? A kid in a TV show or something like that, and guess what's going to come up again? There's $154,000 going on, something here. Now here's 6701. So we got code 6701 up here. We got 6702 down here. We've already discussed that, and there's 6703. So this is 6703 saying there's a power to disaffirm. It's right there in Miller versus Miller. All right? So this goes along with because I've seen different things coming out different ways on this particular exam. So I want to go back there and bring this up again. Let's go to my theory on the cases. Let's go up here to the case like that. What I had been noticing is that the cases they give to you are in order. And I've seen information where they say go to the newest case first because that's going to trump the older case. And then if there's a Supreme Court, Columbia or United States Supreme Court case, that's going to trump the lower court, right? And that's true. However, what I've really noticed is that each case is going to give us an issue that we need to discuss about. The first issue that I talk about right here is Ryan able to disaffirm the contract? Miller v. Miller, and let's go back to what I was jotting down here. Miller v. Miller is disaffirming the contract. Power to disaffirm. Unless he's entitled to recover. I'm pointing at my screen with my finger too, by the way. Bryce is entitled to recover all of it unless 6703 stood in the way. 6703 is the exception to disaffirmation, okay? He put the money in there to take care of both of us, which is 6703. However, the mother did not use the money for that purpose, right? So let's go down here, and what I'm going to do is I'm going to put a bold thing in all caps, analysis. Now, what I'm going to do here, I'm going to come back to it later, because I'm going to go through the next part first. I'm going to go through Brady versus Thomas, then Laredo versus Purcell Fruit Company, and I made my notes. It would not have taken me very long to do what I just did. I just did it in this video. It doesn't take me that long to do, and oddly enough, it's as I'm reading the material. Now, I'm familiar with the material because I did this test live, plus I've looked at it a couple times since. I try not to dwell on it, but I looked at it a couple times, and I was very angry with myself because it's a pretty easy one to work out. But my point here is this case more than likely is going to address this issue, okay? I've seen high-scoring answers in baressays.com where they use the second case, the Brady versus Thomas case, for this disaffirmation thing. But you can see right there in Miller v. Miller that they're talking about the first one, disaffirmation of a contract, because because Bryce, in this particular case, because Bryce could disaffirm the contract with his mother, and she already had a contract with him where she relinquished any right to any money at all. So she, it's not like he's really actually relinquishing a contract with her. She has a contract with him where she doesn't get any of the money. She has no right at any money paid to him with Couch Studios whatsoever. So he doesn't have to disaffirm that contract. He's disaffirming her claim to the money, which he can do, and specifically because he's got this rock solid relinquishing of any right to the money of his. All right. So this relinquishing 6702 up here in the law library, right? So 6702 is going to show up in here as a minor's power to disaffirm. All right. So before this, I got to 6703. It says Bryce is entitled to recover all of it unless this gets in the way. He doesn't need to disaffirm that contract he has with her, but he's disaffirming her claim to the money which the lower court had awarded her, because he's appealing the case against his mother. She already got the right to keep the money. He's saying, no, you don't. You had a contract with me saying you don't get any rights to the money. So he's disaffirming her claim. So you might want to do some analysis on that under there. You go through this same kind of process with each one of the cases, all right? Now, what I wanted to point out, though, and let's go down to the next case, this Brady versus Thomas. You're looking down here, and you're going to see they're going to talk about the CFC 6701 and 2. And I don't know if they mentioned 6703. I don't see it there in a quick perusing of the material. But, so there you go. So there's another thing. You go through this case, you can decide what you need to do. And just like this first case up here for Miller versus Miller, I go down here, I make my notes, right? I make all my notes through here. And then I put down here analysis. I might even want to make another standoff space about it. I spelled it wrong. There you go, analysis. And the red line didn't go under there the first time. Funny. Anyway, so analysis is my note to me to come back and write something original, my own words there, analyzing the disaffirmation. And in this particular instance, I want to also be answering this question. Yeah, in that case, right? So yes, in the Miller case, Bryce is able to disaffirm the award of $26,000 to his mother because he had an absolute contract that where she doesn't have any rights to any of the money. She relinquished any right to it, but yet he still put in money for a safety net, a nest egg for taking care of both of them. And she wasted his money for the good things of life, not for anything for necessities. As a matter of fact, it's the last line right there, right? So there you have it, and Bryce is entitled to the $26,000, and it's a good thing that his mother has had independent and substantial source of income. I just want to make sure that I have that right. Source of income, right? By the way, if I had forgotten this, to put in of income in this particular thing, if I forgot to put that, I'd probably still get a decent score. I wouldn't lose any points for missing a word or two, right? And if I spell some things wrong, I shouldn't lose any points for that either. But anyway, so this is the actual thing. I don't indent anything, I keep it there. But I might also do something like this for my answer. I might put an extra space there, and I might put an extra space there, offsetting this. I don't know if it has the ability to indent in the software, but the other thing you could do is click the whole thing and click indent. But again, I try not to use any of the formatting tools. I try to keep everything with spaces to make everything clear. If I really felt, goofy about it, I'd do it like that and even add more. Unless 6703, and then make that bold. So, hey, guess what? Here it is here, and here it is when we talk about it. I'm going to tell you what it was. And then I'm going to do something in here. They actually do it. They actually say it right here. They say, hey, by the way, in the court's discussion, right? And I want to make a note that this is court discussion. That's another thing I had thought of earlier, court discussion, right? I might want to put that in there too, that I'm going to highlight that. And then this stuff here in analysis, that's all mine. That's all me, right? And I'm not going to say analysis, but I might, right? So I'm going to say my analysis is going to be in our case with Ryan and his mother Janice, right? So Ryan is able to disaffirm the contract because he's a minor. right? Again, this Brian case is actually going to come up, Miller versus Miller. Let's get to Brian versus Thomas. This one here is going to go into that. This is a young man. Craig Thomas appealed a judgment in favor of Craig's former personal manager, Sharon Brady. So he's going after Mrs. Brady, or Ms. Brady. But anyway, so they're saying in this particular case, he can disaffirm the contract. And let me see, I think it's in his second one right here. This young man, okay, here it is. He got a job. In 2001, Craig obtained a recurring acting role on the Acme television network show, The Go-Kart Kid. Some weeks later, Martha sent a certified letter to Brady, so his mother. I'm sorry, Thomas, right? Brady versus Thomas. Okay, so Brady is suing Thomas. But Thomas, Martha Thomas is the mother of Craig, all right? So Craig's mother sent a letter to Ms. Brady stating that Craig no longer needed her management services and can no longer afford to pay. This right here says that the mother is disaffirming a contract with an agent of a minor child. The minor child has the contract because the mother isn't working in the Go-Kart Kid. The kid is working in the Go-Kart Kid. And and then, of course, Brady's going to say he's in breach. Now, what we're going to see here is that the discussion of this is kind of a longer one, but the discussion here is going to be in 6701. So the child can make a contract, okay? So a child can make a contract, and then provided by 6702, that's the disaffirming of the contract. And then 6703, and there it is again, 6702. Oh, and then they tell you right there, right? So do you even need to write the whole thing in there? Maybe not. The Family Code 6702 states, generally, a contract of a minor may be disaffirmed by the minor or the minor's parent or guardian before the majority, before they hit majority, 18, or a reasonable time afterwards. This quote is what you would want to add right there. And basically, you want to add it in with Columbia Code 6702, right? Without typing it all up over here in my worksheet, right? That's what you're looking for there. So you're looking for these things that are going to answer the questions. And so what I said before, where people were using the Brady case for the first one, it is. It specifically states in this second case that 6702 states, generally, a contract of a minor may be disaffirmed by the minor or the minor's parent or guardian before majority or within a reasonable time afterwards, right? The law shields minors from their lack of judgment and yada, yada, yada. Let's look for some other kind of quoted remarks somewhere in here. Here's a magical thing right here. No specific language is required. Now, the reason why I say this is pretty magical, and really happily it's the first sentence of a paragraph here, is it says no specific language is required to communicate. Because what's our second question here? Could he disaffirm the contract? Well, we just see here in the Brady case, yeah, he can. You know, he or his mother can, or his guardian can disaffirm the contract. Okay. Now, did Janice's letter disaffirm the contract for Ryan? Yes, it did. In my opinion, yes, it did. Let's go back up there and look at her little letter. This is the fact file, right? Yeah, I haven't even looked at this stuff yet, but just briefly, she's writing to request the amount of a credit. She wants to reverse the amount. Now, I don't need to see any more on that. I already know what she's talking about. She doesn't want to pay $9,000, which she authorized her child to pay $20. So that's the great part about this. That's Brady. Here we go. Brady, we get down to the bottom. No specific language is required as an intent. She's asking for the money back. So the credit card charged Janice $8,980. She wants that money back. That's pretty much a solid clue to me that she's disaffirming the contract. She's like, no, not only do I don't want to pay this, I want that money back. So that's pretty strong language, and no specific language is required to disaffirm the minor's contract. And then we get into Laredo versus Purcell Fruit. So the big thing I want to think about here is that third question. Between those first two cases, I could, the first case, in all honesty, isn't that tasty to me. It's not that meaty, I should say. And for my vegetarian friends, it's not that meaty like in a nice meaty vegetable. I don't know. But anyway, so for Janice's letter disaffirmed, yeah, it did. The first two cases can answer these first two questions however you want to bounce them around. The fact is, absolutely positively, Ryan can disaffirm the contract. And yes, because he could, Janice's letter didn't need to have any specific language required to disaffirm the contract for Ryan. So now we want to discover if she's liable for the $9,000, $8,980. She authorized $20, not $8,980. So we got to look at this case here, and this should bring up something else. Columbia Civil Code 3802 is mentioned in here, Civil Code 3801, and what else? That's pretty much it. So on this one here, I've looked this over a little bit, so I'm just going to jump on something right here. This case, I want you to read this over on your own and everything else. This is going to be about apparent authority, which is what the child has. Ryan has the apparent authority to enter into the contract. In fact, our boss has already determined that Ryan did enter into the contract, had the authority as an agent to do so, and Janice kind of affirmed that in that, and I want to look at the name for it over here, ratification. Did she approve? See, ratification, and this is an interesting thing about this. Ratification says the principal subsequently approves the agent's actions, accepting liability. That's what ends up happening. However, that's really not what happened here. Janice didn't say, oh yeah, no, I said he can spend $20, but I didn't say he could spend $9,000. So we're going to need to look at the fact file for some more information on that. But in here, the gentleman's name is Hand, okay? So this is Hand, and they are going to claim that Hand is Henry Hand. There he is right there. Henry Hand, and he's going to deal with for $30,000 an orange crop. And in this one here, and they, let me see, after a trial, a jury found in favor of Laredo and awarded her $30,000, and Purcell appealed. So it's Laredo versus Purcell in the lower court, and in the Supreme Court, Purcell is appealing that decision. So I guess that's why they get backwards like that. Okay, Purcell's theory, and everybody's story is the same, but we're going to have to get familiar. We're going to have to cozy up with Civil Code 3801, and let's zip back up there real quick and see what that's all about. 3801 is actual authority, right? So we're going to have to discuss agent, authority, of the agent to act on behalf of a principal. That's really what we're going to have to talk about, okay? So we'll find that up in there. We'll bring that down in our answer. I'm not going to, again, I'm not going to add it in here. I added some stuff up here to show you what I'm doing, but on this side of my answer over here where I'm adding information. But over here, I just want to pick out some things that are going to help us under these other two cases. So Purcell makes a claim that Hand did not and could not reasonably believe that it wished to enter in any contract of sale. Now, I've already read this today and looked at it and everything else, and I've made some notes over here. We'll look at it in a little bit. But I want to talk about is what really came up in this that really blew it away is over many years, Purcell has entered into contracts of sale and consignment. Hand was Purcell's sole agent in Laredo's area. That's the person with the oranges. And then Hand drove a truck provided to him by Purcell, a parent agency right there, in big printed letters, bold letters, Henry Hand, agent for Purcell Fruit Company. You're pretty much stuck with what you got there. You give the man a truck, you put a big sign on the side of it in printed letters, which I assume is like permanently attached with permanent stickers or paint, and it's going to say Henry Hand, agent for Purcell Fruit Company, right on the truck that you own and you gave to this person, Henry Hand, as the sole agent, as a matter of fact, being called an agent right there for Purcell's right there in the discussion. So it's pretty much that, yeah, Henry Hand. Now, what does this really answer, okay? So we have to look at the different things that they're pulling up, and it says 3802, and I got to tell you, it's in my answer down here somewhere. We'll go back into that in a second. 6702, power to this. Oh, here we go. So these are what these things are, and these are the notes that I made. Agency defined, actual authority, apparent authority, and then creation of actual authority. But there's one more thing down there, and that was CCC 3810, right? So I'm going to have to go back up there and take a look at that, and let's just pop up there real quick to those 3810 binding effect, right? So this is binding effect. That's what's in this particular case. In this last case, there's a binding effect, and we're going to have to know that. And it's like any act of an agent within, the scope of his or her actual or apparent, authority binds the principal. Okay, so this is not going to be good for us, right? Like I kind of see that. Let me stand that off a little bit here, and I'll make this like this. Now, this is actually the whole thing, and I'll end up putting this in my answer here. But Laredo versus Fruit Company, Purcell Fruit Company. Now, I'm going to take a break here. This is the end of this, and then we get into the these other sections. We get into the law and stuff like that. But that's the end of the thing. That's the last case, all right? The Henry Hand agent for Purcell Fruit Company. That's the end of that case, right? But what we get out of that is we get the agency stuff, the 38, 0102, apparent authority and a binding effect. So, and the bottom line here is any act of an agent, right here on the left, any act of the agent within the scope, and I want to say course and scope because that's the way I would write it myself in that particular thing. Any act of an agent within the course and scope of his or her actual or apparent authority binds the principal. You're done. It's pretty much, you're not getting out of it at that point, right? So you got apparent authority and all this kind of stuff, but there is apparent authority, and you have all these facts that just crush it against Purcell that, no, there is a contract. And the case affirmed the judgment that, lo and behold, there is a contract. As well as there unquestionably a contract for sale between Laredo and Purcell. It's the bottom line. It's the last line. Bottom line, judgment's affirmed, right? So you got to pay $30,000 for these oranges. So let's go over here now. I'm just going to slide up here to the main page. Let me see here. 2020. Okay, this is the fact file. We're going to get up into the fact file. There we go. So that's our memo. This is our task memo over here. So then we'll go up into the fact file. Now I did scroll back and forth a little bit on the right-hand side. But my idea, my goal, my objective and everything is to just stick with scrolling through once. And I want to go through and I want to pull this information out on this side on the left like I did in the Miller versus Miller case. So all this stuff down to, actually, I'm sorry, not that one. It's up here when I'm making my notes. So I went up here and so the first thing I did, just a recap here as we wrap it up. This is the first note that I make when I go through the performance task. I take this note, and this is going to be from the task memo, and this is going to be my outline in my answer for how I'm going to answer the question. And I repeat these questions here because I'm going to address them, and I want to make sure absolutely positively that I address them. Now, before I go any further, I'm going to zip to the bottom of my file here, and you're going to see that they're listed again. I want to list them at the end of my thing because I'm going to fatten all this stuff out, and this is going to get pushed down to the bottom. I want to make sure that I can review at the end before I submit it and have that conclusion that, yeah, he's going to disaffirm. Yes, Janice's letter did successfully disaffirm, but however, I'm going to find that this young lad, Ryan, did indeed lock his mom up for the 8980. And that, barring any negotiations about how that works, we need to go through the fact file to, clean that up a little bit, right? Let me go up here to the Miller thing down here. So we go through the fact file, and then you can read through this on your own. There's a contract that he entered into. I don't want to do that. I could actually go to it, right? It's actually a hyperlink. Go figure. Anyways, so we have this stuff. It's an under 18-year-old. It's a click contract. She says you can spend no more than $20. And so we go into the contract thing, and let me see here. Okay, so here we go. The system called GamerTrack's Treasure. Somehow, some way, to me, this doesn't seem like it's something where you're going to keep continuing putting money into the system. And as a gamer myself, I got to tell you, this is you pay money to get better weapons and options and stuff like that. That's what this whole paragraph is about, by the way. This is going to be two things: pay to play, pay to win, right? So you want to pay to get your, you don't want to go do the grind through the game and get all the options and everything that you can get for free. You're going to pay extra money, real world dollars, and you're going to get these tokens or whatever that you can do to acquire these extra weapons and stuff, but they cost real world dollars. But because they're calling this thing the Gamer Tracks Treasure thing, I have a problem with that because they're using the kids to bankrupt their parents on these games because they think they're just getting all these great things in the game. And ironically, they're bankrupting their parents on these credit cards. You've seen the stories too often, all right? So they described that the treasure thing, and he's limited to $20. And she started out and she was charged $20, but then he keeps playing this game and obtained numerous options and things, end up paying $9,000, an additional $8,980 after he already started. So this kind of hit her from out of the blue. She had no idea about this. And then she wrote the letter, that's the other thing, in the fact file, and she's disaffirming that contract. And she doesn't want to pay this, and that's her whole thing to us in the task memo. She wants to, our boss gives us the thing in the task memo that before she talks, so she can discuss, so our boss, Marjorie Turner, can discuss with Janice her options. She wants to know what the facts are. And it looks like she's kind of stuck with the $8,980 charge, barring any arbitration, negotiation, or whatever than that. But it's like, it appears to me, painfully, that she would be, based on the information and the statutes and everything else, that she'd be stuck paying that money. Now, let me go into my answer here. I got a blank spot, and then I got where my answer really starts. This is not a complete answer. Remember up at the top here, I said this is the first things I write down. And then the cases I write down as well, right? But in my answer, when I start out my answer, it's a memorandum. They're asking us to write a memorandum. So I'm going to write a memorandum, and who is it for? It's going to Marjorie Turner. It's from me, the applicant. I write military type date, so I put the date on there. Marjorie Turner really enjoys that I'm a military veteran, and she enjoys that I date things that way. Now, read the potential right litigation. That's the note coming to me. My note going back is answers to questions, just so that my boss, at a notice, just looking at the top, my boss notices what's going on. This becomes my introduction paragraph. And rather than center this as an introduction and really set it off, I'm just writing an introduction because that's what it is. And then I go down here. Now notice that this doesn't look exactly the same down here. All right? This is all the identical. It's the same thing. But I added something here because I had gone through and I noticed I was going to be adding these different things in here. So what I did is I put an explanation right here. So I'll read that to you. It says, in this discussion, reference to the following sections, Columbia Civil Code sections as CCC number and Columbia Family Code sections as CFC number. That's not for my boss. My boss could care less. That's for the grader, so that I put it in my answer so that the grader knows anytime they see something like that, they're going to see it like this. I'm not writing that whole thing out again. All right. Now, another thing I want to mention is this is kind of my answer when I was actually working through it on my own. And you see my analysis down here and analysis down here. Now, I haven't worked on this thing all the way through. I will be doing that over the next couple of days. But then I have an analysis here. This is court discussion, right, that I talked about before. This is the whole rule here. This is that whole rule to that particular issue, the disaffirming and all that. And also, the one thing that you don't have, this says the case. This doesn't have that question up there, right? So what I might be doing on that is to take this, and I don't like canceling it. I don't like cutting things out. But I would do this. Bam. So actually what I would do is I'd be answering underneath those. I would find the information that gets that done, and I would do it. So minor's power to contract, yeah, our boss told us that the minor had the power to contract, and did indeed, they found a contract. So I'm just going to mention that they can enter into a contract. And that came from Miller versus Miller. And then minor's power to disaffirm, that was also mentioned in that same case. So I'll be doing some talking about there that the minor can make a contract and it's a valid contract. I'll just be saying it because they discuss it. Then I'll go back into the other one and say that the minor has a power to disaffirm. However, Miller versus Miller, that was a disaffirmation of her being able to keep that $26,000, and that I guess Bryce was really allowed to have that $26,000. In the next case, there it is, $26,000. In the next case, that's answering the first one as well. So I would bring this up in there because they're going to say the power to contract discussed above. right? And then the minor's power to disaffirm, except for as provided in 6703, that's exactly updated up in here, right? Bold. Except as provided for in CFC 6703. So that's in the Brady case. So I need to bring that up as well. So I'm going to mention Miller to me, because they're talking about the power to contract. I'll use that. The next thing they're going to talk about is power to disaffirm, but I have to distinguish that he's not disaffirming the contract with his mother, that she has no rights to the money. I'm going to say that he's disaffirming that she has any right to the money because a lower court awarded her the $26,000 and that she wasn't liable to give her son back the $26,000. That is what the disaffirmation is all about, that she's claiming that she had the right to it when no, Bryce had the contract with her disavowing any claim to the money whatsoever. So that would be the discussion. Even though it says minor's power to disaffirm, that's the way I'll describe it there. Then, and with this is just explaining more that, hey, she spent the money for good times, not food and health, shelter and health and all that. In the Brady versus Thomas case, I would find it that the power to disaffirm in the Brady versus Thomas, Mrs. Thomas and her son are canceling the Brady contract. Brady sued them. Now they're appealing because they apparently, have to appeal it. So I would go ahead and discuss in this particular, somewhere I would take this information about that because they are specifically disaffirming exactly, without this exception at 6703, the contract of the minor. And they could. And the court in Brady said they could. So I would actually go up into this Miller section or this disaffirmation. I mentioned Miller here, that the contract's available and the power to disaffirm, but I would also bring up the Brady case in my analysis. That's what I'm trying to say. As a matter of fact, let me get rid of the bold here and ... And I say discuss Brady, right? Discuss Brady here, right? Because that is specifically a contract that they're being able to disaffirm, right? And then in the last one, again, let's go to the bottom. Can Ryan disaffirm the contract? Yeah, absolutely. There's no question. If so, yes, he could. Did Janice's letter disaffirm the contract with Ryan? Yes, because the court said in Brady versus Thomas there, no specific language is required to communicate the intent to disaffirm the minor's contract. And specifically in the letter, would be my analysis down here, as a matter of fact. Let's go ahead and put that in there, right? Bold analysis. Now this, right? So we're going to put that there. And in there, we're going to discuss the very fact that, hey, her asking for the money back or to get the credit back and not have to pay that $8,980, she is absolutely disaffirming the right for her son to do that. Meaning she's canceling that contract because her son's never going to be able to play that game again. Probably physically, right? Anyway, so let's go into this. Is Janice liable for the $8,980? And unfortunately for her, this code right here says any agent within the, I'm going to have to say course and scope. It's in my mind every time I say that, it's course and scope. He is within the course and scope. He got permission from his mother. If you read the fact file on this one here, which is right there, if you read it, go through this, that she gave him permission to go ahead and spend the $20 bucks, but she also answered back. Janice gave Ryan permission. Ryan opened up the account. And down here, right here, and there it is. GamerTrax contacted Janice and she verified that she had given Ryan permission. They're not going to go in, did you give him permission to spend $10,000? They're not going to ask that. For some reason, GamerTrax isn't going to answer that when they talk about the treasure account. And then he started playing the game and racked up to $8,980, all right? So there you have it. She's probably on the line, on the hook for the 80. If you want to get some kind of creative there, you feel bad for her, maybe do, maybe don't. But this is an unfortunate thing, and I would, say, recommend discussion with the company. Have the lawyer, have our firm as the lawyers contact GamerTrax and say, hey, she authorized $20 and you charge her $9,000, and in your right mind, how could you possibly say that that's even, how in the world How in the world could this game company who's marketing to minors stand on the fact that they're going to keep $8,980 when she only gave her son permission to play the game, not not bankrupt their mother, the mothers, right? So that's the way it is. So that's going to wrap it up on this. Sorry this went longer than I expected it to. If you have any questions, comments, or anything, you can make comments below the video. I do see those. Make sure you hit the thumbs up, like the video, make a comment below, let me know you came by to say hi. And also, if you're a member of YouTube, subscribe to the channel. I greatly appreciate the growth on the network. And along those lines, also, let me put my face back up here for the ending, right? One more transition there. By all means, let me know what you think about the video. It went longer. It's an hour and 10 minutes. Sorry about that, but I think it's an hour and 10 minutes that really help you get a gist of what I'm talking about in this. No matter what the performance test asks. I don't care if it's a letter. I don't care if they want me to write a new song for Taylor Swift. Swiftie. I don't care if they want me to write a new telenovela. I don't care what it is, or a memo. I want a memo because it's just simply the easiest thing to write. But if they ask me for anything, no matter what, I'm going through the same exact process. I'm going to go through and grab the task memo. I'm going to take the task memo, insert that in reworded words to be my outline for how I'm going to answer the question, the performance test. That's my blueprint for how I'm going to answer the thing. Then I'm going to the law library table of contents, and I'm going to put the cases in my answer window because we have to use them. We have to use that stuff. Now, in this particular case, in the October 2020 exam, let me back down here for a second. In this, they had all this stuff, all this crazy information. Not page 5 there, question 5. But underneath that, in the law library, they had all these stupid things on the Columbia Civil Code and Family Code. And that is what screwed me up. There was so much writing, typing, and stuff going on there. And I'm like, this is not answering the question. It is, but I didn't really look at it, in detail. I know agency cold. I know this stuff. It is my wheelhouse. Home run, right? It's great stuff. And I understand it completely. Being a business owner, being these different types, it was a corporation, was a general partnership, was a limited partnership, was different types of corporations. I absolutely positively get it. I know why things are done. I understand why things are done, protecting the company. All right. And I see all this stuff in here and I'm like, what in the world? But because I had never done a scrolling one side by side like that, it wasn't. It was top and bottom. It was even worse. So it was really, really hard. So the scrolling through is a problem. It is a time waster. So to be able to scroll through this thing one time and yank this information out, extract the information, again, over on the left side of the screen. Let me get rid of my face again. So we can see what's going on here. Get rid of my face. And so over on the left-hand side, I'm pulling this information out of the thing. I got the test memo. I know what I got to do. I know how I got to get the job done. I have to answer these questions. Unquestionably answer the questions. That is what the performance test is all about. Then go down there and grab the cases. Let me get rid of all these other cases. All right, because I kind of go by how I'm doing things, and things get really crazy, right? So I'm going to just delete this stuff that I was working for here with y'all on. And I just want to demonstrate that really all I got is the cases, right? So I just put the cases into my answer. This is what I do when I go into the performance test. I grab information. I grab absolutely positively the best things that I think I can grab. Ms. Turner, this is my template up here. All this is my template. This is what I got to do and answer the question. And then I need to have all these cases somewhere, somehow, some way. These cases have to be in my answer to say that's where I'm getting the information. That's where I'm getting the law from. And then I go through and I clean up my initial page, right? And I get my memorandum and I get, this is the stuff I didn't put in there, right? So when I'm going back up in there and I'm going through the fact file is when I actually do this. So you went through the law library, got your information, you pulled your law, your issues, your law, your discussion from the court, you pulled all that information out, you get ready to do your analysis, you go back up to the fact file so you can analyze it all. That's when I go back up and I put the memorandum in. That's when I write introduction right there. That's when I added this thing here. You know what? That period should be inside that. bing, cleaned it up nice and neat. So that should be in there, right? So I got this information. This is a note for the grader. This is not, my boss could care less. They know what I do. They know how I do it. And then I go down in there I pulled my answer out. So one, is he able to do that? Control X, I'll put them back. B, all right? So I go through and take the italics off. There we go. All right, so I just want to make sure that I got everything down, everything nice and neat, and I put that in there. Now, the Miller versus Miller and these other cases and stuff like that I'm putting in there, I actually plug them in between the answer. So I do my analysis right there. All this stuff that I'm going to use from the disaffirming of the contract, I put all that information there, okay? And that's like the Miller versus Miller and stuff like that you see down here, right? So I put that between these things. So I fatten it out, which why I put them at the very bottom end. When I get down to the bottom of the page, I want to know, did I answer those 3 questions? And wrap it up right then and there, all right? Again, let's put my big mug back up on the screen to wrap this thing up, right? So here's the point. This is how I go through there. I go to the task memo, I grab my outline, I reword the task memo to be my outline for precisely how I'm going to answer the question. That is my introduction paragraph, okay? The PT book says you need an introduction paragraph. I stopped reading at that point and I said, I'm making an outline for my answer. That's what my introduction is. Hey, how you doing? This is what you're going to read below. Just like in high school. You write your report, you're doing a research report or whatever. The first paragraph is going to be an introduction to the subject, and it's going to describe the next 3 paragraphs that you do. So the next paragraph is that first sentence. The second paragraph is the second sentence of the first paragraph. And the last paragraph is the last sentence. And then you come up to your conclusion. And that's what I decided I would be doing on the performance test. And then I go through the case law, I'll just pull the information out, slap it in my answer because it's going to be there. So I'm outlining my answer in the answer window. I'm outlining the performance test in the answer window. Okay, it's got to be, if we take 20, 30, 40 minutes to outline, whatever time it is, 100% of my time outlining is going to be part of my answer. So on the old essays or whatever, if you're taking 20 minutes to outline your essay and the rest of your time you're going to be writing it, that's fine. If you had an hour and you took 20 minutes, that 20 minutes goes on the back end of my answer. I got an hour and 20 minutes. How is that possible? If 20 minutes is used for outlining and I'm outlining in my answer window, 100% of my outline, the entire 20 minutes, is part of my answer. I just turned 60 minutes into 80 minutes. And that's some powerful stuff. It's going to take me longer to outline a performance test. 100% of that time outlining is coming off the 90 minutes we get, but it's being added right back in because it's part of my answer. All I got to do is put it in the right spot. And if I do it neatly, effectively, and efficiently enough the first time through, I don't have to waste time organizing, moving things around, or anything like that. And it allows me to take time to think about it. One last thing before I let you go. Thanks for staying this long. Don't forget to give me the thumbs up and like the video, subscribe and all that. Like, subscribe, comment, and all that, and share. You may not want to share now because everybody taking the same exam as we are is our competition. But by all means, feel free to share. I just want everybody to pass. Stupid exam. But there are a couple of ways to look at this. Real quick. I have the ability to read very quickly. All right. So what I actually normally do is I read from the task memo through the fact file, through the law. I just read straight through because we're scrolling this stupid thing on a computer screen and it's hard to read. If I think that I might have any kind of issue whatsoever, I default back to, the first thing I do is I go to the task memo and write in the answer file anyway. That's always going to happen that way. But if I think there's any kind of hiccup going to happen or I feel a little queasy, then I'll jump down to the law library, slap the cases in, and just start working through the cases because they should start to make sense. The first thing that I write, that fact file introduction paragraph thing that I set up, that first thing should give my mind enough information to be ready to accept the data from the law library to be able to successfully answer my question. All right? And again, the other things you can do is you can bounce from the task file to the table of contents for the law library, to the files, grab your information. The other thing you can do, so two things. The other thing you can do is just read straight through, okay? If you're a fast reader, if you have great reading comprehension, if you got these, if it just happens to be in an area of law that's in your wheelhouse, home run, then go ahead and do it. And in any case, do it however you feel best to do it. But in any case, no matter what, I can always do it the same way. I don't care what they're asking me for. Task memo, do my introduction paragraph, outline my answer. Go to the table of contents for the law library, make sure I got the cases listed because we're going to have to discuss them. Any case within a case, put it underneath the case that it came from. All right? So if you have John versus Doe and then Doe versus Pete, that is mentioned within that case, I put it right there underneath that other case. All right? So I keep them all in order. All right? If you have any questions, use the Ray Hayden Facebook group on the California discussion, Ray Hayden's California bar discussion, whatever. Use that group. Ask me questions underneath the video link that I put on the page, okay? And until I catch you in the next video, take care, be well, kick ass, take names on the California bar, and I really want to see your names on the pass list. Don't worry about me. I want your name on there, okay? I'll get there eventually, all right? We'll talk later. Take care and be well.